So I want to clarify something real quick here. Uh, a lot of people use they use the terminology and the language as case law, and I want you to be able to let this resonate and marinate in your mind. The courts do not have the ability; they are not authorized by we the people to create law. Period. So there is no such thing as case law. What there is case precedent. Okay, it's the opinion of other people who have evaluated, and in many cases are uh, very knowledgeable on the subject matters. Okay, at hand, and they're creating what is case precedent. Okay, it's not case law because the courts don't have the ability to make law. Okay. So legal status, civil status, and political constitutional status. The following cites from the U.S. versus Wong Kim Ark confirms our research on citizenship by admitting that there are two components that determine citizenship status: nationality and domicile. In Undy versus Undy, 1869, L period R period 1 H period L period SC period 441, the point decided was one of inheritance, depending upon the question whether the domicile of the father was in England or in Scotland. He being, in either alternative, a British subject, lord, chancellor. Hathaway said, the question of naturalization and of allegiance is distinct from that of domicile. Page 452, Lord Westbury, in the passage relied on by the Council of the United States, began by saying, the law of England and of almost all civilized countries ascribe to each individual at his birth two distinct legal states or conditions, one by virtue of which he became the subject, national, of some particular country, binding him by the tie of natural allegiance, and which may be called his political status, another by virtue of which he has ascribed to him the character of a citizen of some particular country, and as such it is possessed of certain municipal rights, and subject to certain obligations, which latter character is the civil status or condition of the individual, and may be quite different from his political status. And then, while maintaining that the civil status is universally governed by the single principle of domicile, domicilium, the criterion established by international law for the purpose of determining civil status and the basis on which the personal rights of the party, that is to say, the law which determines his majority or minority, his marriage, succession, testacy, or intestacy, must depend, he yet distinctly recognize that a man's political status has country, patria, and his nationality. That is, natural allegiance may depend on different laws in different countries. Page 457, 460. He evidently used the word citizen not as equivalent to subject, but rather to inhabitant, and had no thought of impeaching the established rule that all persons born under British dominion are natural-born subjects. United States versus Wong Kim Ark, 169, U.S. 649, 18, S period, CT period, 456, 42, L period, ED period, 890. This case was had in 1898. So, the Constitution is a political and not a legal document in relation to citizens and residents. It therefore determines the political status rather than legal statutory status of those citizens and residents. 2. Nationality determines your political status and whether you are a subject of the country. 3. Domicile determines your civil and legal status and statutory status. It does not determine your political status or nationality. 4. Being a constitutional citizen per the 14th Amendment is associated with nationality, not domicile. 5. Allegiance is associated with nationality, not domicile. Allegiance is what makes one a subject of a country. 6. Your municipal rights, meaning statutory civil rights, associated with your choice of legal domicile, not your nationality or what country you are a subject of or have allegiance to. 7. Being a statutory citizen is associated with domicile, not nationality, because it is associated with being an inhabitant rather than a subject. 8. A statutory alien under most acts of Congress is a person with a foreign domicile, not a foreign nationality. By foreign, we mean 8.1, constitutional context, outside of country, United States. 8.2, statutory context, outside of territory, federal territory, and the exclusive federal jurisdiction, and not outside the constitutional United States, which is protected by the organic Constitution for the states of the Union. The above is also completely consistent with the following articles. We know that nationality per Title 8 U.S.C. subsection 1101A21 and the 14th Amendment constitutional citizenship are not the same. So, much like the chicken and the egg analogy, what happens first, nationality or the 14th Amendment constitutional citizenship? Or does that occur simultaneously? It might at first appear that from the analysts in this pamphlet that the 14th Amendment constitutional citizen also applies to inhabitants of unincorporated and unorganized territory. But, as pointed out by the court in Wong Kim Ark Supra, the domicile determines civil status. Thus, 14th Amendment constitutional citizenship on U.S. territory is inferior to that of the 14th Amendment constitutional citizenship on the Union, but only by virtue of domicile. Change domicile and improve, denigrate your legal status either for the better or the worst, as the case may be. Nationality, therefore, cannot be the same thing as constitutional citizenship, because citizens of America Samoa and Swanee Islands are not constitutional citizens according to the courts, yet they have the following status. Political status. 1.1, National of the United States, Title 8 U.S.C. subsection 1101A21, and 1.2, National of the United States of America, Perkins versus ELG 307 U.S. 325, 1939, and 2, Civil status, national but not citizen of the United States at birth, Title 8 U.S.C. subsection 1408 and Title 8 U.S.C. subsection 1452. So it must be concluded that nationality and constitutional, ergo 14th Amendment citizenship are not the same. From the above article and the U.S. Supreme Court's own analyst above, it follows that a national of the United States, a constitutional protected member of the Union of States, cannot be a citizen or a resident under federal statutory law without one of the following two conditions existing. 1. You are physically present on federal territory at some point and legally domiciled there. This means the government, as moving party, has the burden of proving that you submitted a form indicating a permanent address in the statutory but not constitutional United States of America, and that you meant that the United States indicated meant federal territory not within any state of the Union. This is impossible if you attach the following to every government form that you assign. 2. You are representing a government entity that is domiciled on federal territory, such as a federal and not state corporation, as a public officer or holding public office, for instance. Hence, Federal Rules of Civil Procedure 17b must apply, but they must produce evidence that you are lawfully occupying said public office and may not presume that you do. Simply citing a provision of the Internal Revenue Code, IRC, and thereby claiming the benefit of that franchise, for instance, is insufficient to create said office. It must be created by some other means because the Internal Revenue Code, IRC, doesn't authorize the creation of any new public offices, but regulates existing public offices. There is no other way for federal law from a legislatively foreign jurisdiction to be applied against a state citizen domiciled within a constitutional and not statutory state. Option 2 is the method most frequently used to legally but not physically kidnap most people and move their legal identity to federal territories. For diagrams that depict how domicile and nationality interact to determine the legal status of a person, see Section 13 of the following later. Supreme Court definition of constitutional citizen. The U.S. Supreme Court defined what a constitutional citizen is in the following ruling. Under our own system of polity, the term citizen implying the same or similar relation to the government and to society which appertain to the term subject in England is familiar to all. Under either system, the term used is designed to apply to man in his individual character and to his natural capacity, to a being or agent public officer, possessing social and political rights and sustaining social, political, and moral obligations. It is in the It is in this exception only, therefore, that the term citizen in the article of the Constitution can be received and understood. When distributing the judicial power, the article extends it to controversies between citizens of different states. This must mean the natural physical being composing those separate communities and can by no violence of interpretation be made to signify artificial, incorporeal, theoretical, and invisible creations. A corporation, therefore, being not a natural person, but a mere creature of the mind, invisible and intangible, cannot be a citizen of a state or of the United States, and cannot fall within the terms of the power of the above-mentioned articles, and can therefore neither plead nor be impleaded in the courts of the United States. Sir Edward Coke has declared that a corporation cannot commit treason, felony, or other crime. Neither is it capable of suffering a traitor's or felon's punishment, for it is not liable to corporeal penalties, that it can perform no personal duties, for it cannot take an oath for the due execution of an office, neither can it be arrested or committed to prison. For its existence being ideal, no man can arrest it, neither can it be excommunicated, for it has no soul. But these doctrines of Lord Coke were founded upon an apprehension of the law now treated as antiquated and obsolete. His lordship did not anticipate an improvement by which a corporation could be transferred into a citizen, and by that transformation be given a physical existence, and endowed with soul and body too. The incongruities here attempt to be shown as necessarily deducible from the decisions of the case of Bank of the United States versus DeVox and of Cincinnati and Louisville Railroad Company versus Leston afford some illustration of the effects which must ever follow a departure from the settled principles of the law. These principles are always traceable to a wise and deeply founded experience. They are therefore ever consentaneous and in harmony with themselves and with reason, and whenever abandoned as guides to the judicial course, the aberration must lead to bewildering uncertainty and confusion. Conducted by these principles, consecrated both by time and the obedience of sages. I am brought to the following conclusion. First, that by no sound or reasonable interpretation can a corporation, a mere faculty in law, be transformed into a citizen or treated as a constitutional citizen. And two, that the second section of the third article of the Constitution investing the courts of the United States with jurisdiction in controversies between citizens of a different states cannot be made to embrace controversies to which corporations and not citizens are parties, and that the assumption by those courts of jurisdiction in such cases must involve a palpable infraction of the article and section just referred to. And three, that in the cause before us, the party defendant in the circuit court, having been a corporation created by the state of New Jersey, the circuit court could not properly take cognizance thereof, and therefore this cause should be remanded to the circuit court with the directions that it be dismissed for the want of jurisdiction. Rundle versus Delaware and Retain Canal Company, 55 U.S. 8090, 1852, from dissenting opinion of Justice Daniel. In the above ruling, what we call a statutory citizen is referenced and described as artificial, incorporeal, theoretical, invisible creation, a mere creature of the mind, meaning a creation of Congress, invisible and intangible. Note also that even a constitutional citizen, and therefore human being or man above, is referred to as a being or agent public officer, possessing social and political rights and sustaining social, political, and moral obligations. Rundle versus Delaware and Retain Canal Company, 55 U.S. 8099, 1852 is the year of the case, from dissenting opinion by Justice Daniels. The social, political, and moral obligations spoken of above, in fact, can only attach to a government office or officer exercising agency on behalf of the government franchise grantor called citizen. Otherwise, they would represent a theft of otherwise private property under the Fifth Amendment. That office is created by the act of choosing a civil domicile within a constitutional state. That is why the 14th Amendment says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. To reside has been held by the courts to imply a domicile rather than merely physical presence in the state. Without such a choice of domicile, the office is not created and its obligation cannot lawfully be enforced in any civil court of law. Statutory citizen resident status is entirely voluntary and discretionary. Constitutional citizen nationality status is not. An important distinction that needs to be understood by the reader is that no one can force you to acquire or retain domicile anywhere, including within the federal zone, or to accept the civil status that attaches to it, such as statutory citizen or resident. The status is entirely voluntary and discretionary. That is one of the conclusions of the following pamphlet. Why? Because the legal status you use to describe yourself is how you contract with other parties, including the government. The purpose of establishing government, in fact, is to protect your right to both contract and not contract, as upheld by Article 1, Section 10 of the Federal Constitution and in all 50 state constitutions as well, as you see fit. You don't become a person under a private contract until you sign or consent in some way to the contract or agreement. 2. Politically and legally associate with groups you choose to associate with. The right of freedom of association and freedom from compelled association is protected by the First Amendment to the United States Constitution. Number 3. Choose or nominate the civil government that you want to protect your right to life, liberty, and property. 3.1. Choosing a domicile is an act of political association that has legal consequences in which you nominate a specific municipal government to protect your rights and property. 3.2. If you never nominate such a government, then you retain the right to protect yourself and are not entitled to the protections of a specific municipal government protector. This is why the Declaration of Independence says that all just powers of government are derived from the consent of the people. Those who don't consent can't be civilly governed. Yes, they are still liable for criminal violations because the criminal laws do not require consent. Civil statutory codes, which are franchises, however, do require consent of the governed, and all such civil statutory code franchises attach to and associate with your choice of legal domicile. Domicile is how you exercise rights number 2 and 3 above. You can't be a statutory citizen without choosing and consenting to a civil domicile in a federal zone or federal territory, or otherwise a subsidiary corporation of Title 28, 3002, 15A, or be a resident inhabitant of Washington, D.C., District of Criminals. You get to decide where your domicile is, and you can change it at any time. If you don't want to be a statutory citizen under federal law, change your domicile to a state of the Union and correctly reflect that fact on government forms and correspondence. The legal definition of citizen confirms that the status is voluntary. Notice the phrase, in their associated capacity, which is a First Amendment, voluntary act of political association. What the government doesn't want you to know is what status would you describe yourself with if you do not consent to volunteer and yet did not expatriate your nationality to become a constitutional alien. Citizen, one who under the Constitution and laws of the United States, the constitutionally protected citizen through the Union of States, or of a particular state, is a member of the political community owing allegiance and being entitled to the enjoyment of full civil rights. All persons born or naturalized in the United States, the constitutionally protected United States, and subject to the jurisdiction thereof are citizens of the United States, the constitutionally organic protected United States, and of the state wherein they reside. U.S. Constitution, 14th Amendment, see citizenship. Citizens are members of a political community who, in their associated capacity, have established or submitted themselves to the dominion of a government by giving up their rights for the promotion of their general welfare and the protection of their individual as well as collective rights. Herritt versus City of Seattle, 81 Washington 2D 448 500 page P.2D 101 109. Black's Law Dictionary 6th edition page 244. The full civil rights they are talking about above are enforced through municipal civil codes franchises, which in turn can only attach to one's choice of legal domicile. Here's how the courts describe this process of volunteering to become a statutory citizen. The people of the United States residents within any state are subject to two governments, one state and the other national, but there need be no conflict between the two. The powers which one possesses, the other does not. They are established for different purposes and have separate jurisdictions. Together they make one whole and furnish the people of the United States with a complete government, ample for the protection of all their rights at home and abroad. True, it may sometimes happen that a person is amenable to both jurisdictions for one and the same act. Thus, if a marshal of the United States is unlawfully resisted while executing the process of the courts within a state, and the resistance is accompanied by an assault on the officer, the sovereignty of the United States is violated by the resistance, and that of the state by the breach of the peace in the assault. So too, if one passes a counterfeited coin of the United States within a state, it may be an offense against the United States and the state. The United States, because it's discredited because it discredited the coin, and the state because of the fraud upon him to whom it is passed. This does not, however, necessarily imply that the two governments possess powers in common or bring them into conflict with each other. It is the natural consequence of citizenship, 92 U.S. 542, 551, which owes allegiance to two sovereignties and claims protection from both. The citizen cannot complain because he has voluntarily submitted himself to such a form of government. He owes allegiance to the two departments, so to speak, and within their respective spheres must pay the penalties which each exacts for disobedience to its laws. In return, he can demand protection from each within its own jurisdiction. United States versus Cruikshank, 92 U.S. 542, 1875, emphasis added. If the status is voluntary, then there must be some way to unvolunteer, right? How is it that the citizen cannot complain? Because if he didn't voluntarily submit himself to a specific state or national government by choosing a civil domicile within the specific government and thereby become subject to the civil code franchises of that place, he wouldn't call himself a statutory citizen under the civil code franchise to begin with. Instead, he would call him or herself any of the following terms in relation to that specific government and on all government forms he or she fills out. This is the huge secret that no one in government or the courts want to talk about. In fact, and will hide at every opportunity because it renders them completely powerless to govern you civilly. Those who don't volunteer are called by any of the following names other than statutory citizen. 1. Non-resident. 2. Transient foreigner. 3. Stateless person. 4. In transitu. 5. Transient. And 6. Sojourner. The state's courts recognize that calling oneself a U.S. citizen is voluntary, and hence that you can instead refer to yourself as simply a non-resident so as to avoid being confused with a statutory citizen as follows. We find nothing which requires that a citizen of a state must also be a citizen of the United States, if no question of federal rights or jurisdiction is involved. Cross versus BD of Superbs of Elections, 221A, period 2D, period 431, 1966. The Foreign Affairs Manual, FAM, Department of State, also confirms that calling oneself a U.S. citizen or a citizen of the United States is voluntary with the following language. 7. Foreign Affairs Manual, FAM, Section 012A. A U.S. national eligible for consular protection and other services. Nationality is the principal relationship that connects an individual to a state. International law recognizes the right of a state to afford diplomatic and consular protection to its nationals and to represent their interests. Under U.S. law, the term national is inclusive of citizen, but citizen is not inclusive of nationals. All U.S. citizens are U.S. nationals. Section 101A22 INA, Title 8 U.S.C. subsection 1101A22 provides that the term national of the United States means A, a citizen of the United States, or B, a person who, though not a citizen of the United States, Title 28, 3002, 15A, owes permanent allegiance to the United States. U.S. nationals are eligible for U.S. consular protection. Okay? Below is an example of a case involving a party who had no civil domicile in either statutory state, meaning federal territory, or a constitutional state of the Union, and hence was classified by the court as a stateless person who had to be dismissed from a class action lawsuit because he was beyond the civil jurisdiction of the federal court. In order to be a citizen of a state within the meaning of the diversity statute, a natural person must both be a citizen of the United States and be domiciled within the state. See Robertson versus Cease, 97 U.S. 646, 648-649. This case was upheld in 1878. Brown versus Keene, Keene, at Pet 112, 115. This case was upheld in 1834. The problem in this case is that Bettenson, although a United States citizen, has no domicile in any state. He is therefore stateless. For purposes of subsection 1332A3, subsection 1332A2, which confers jurisdiction in the district court when a citizen of the state sues aliens only, also could not be satisfied because Bettenson is a United States citizen. 490 U.S. 829. When a plaintiff sues more than one defendant in a diversity action, the plaintiff must meet the requirements of the diversity statutes for each defendant or face dismissal. Starbridge versus Curtis, 3 Cranch, 267, 1806. 1. Here, Betson's stateless status destroyed complete diversity under subsection 1332A3, and his United States citizenship destroyed complete diversity under subsection 1332A2. Instead of dismissing the case, however, the Court of Appeals panel granted Newman Green's motion, which it had invited, to amend the complaint to drop Benson as a party, thereby producing complete diversity under subsection 1332A2. 832 F.2D 417 in 1987 is when this decision was rendered. The panel, in an opinion by Judge Eastbrook, relied both on Title 28 U.S.C. subsection 1653 and on Rule 21 of the Federal Rules of Civil Procedure as source of its authority to grant this motion. The panel noted that because the grantors are jointly and severally liable, Benson is not an indispensable party, and dismissing him would not prejudice the remaining grantors. 832 F.2D at 420, citing Federal Rules of Civil Procedure 19B. The panel then proceeded to the merits of the case, ruling in Newman Green's favor in large part, but remanding to allow the district court to quantify damages and to resolve certain minor issues. 2. Newman Green versus Alfonso Loren, 490 U.S. 826, 1989. Only those who are constitutional aliens when physically present within a foreign country can be forced to submit themselves to the civil jurisdiction of that country absent their consent and voluntary choice of domicile. Those who are not constitutional aliens, such as state nationals, cannot be forced and must consent to be governed by choosing a domicile. The U.S. Supreme Court describes the process of forcing aliens into privileged status to have a residence in the place and be subject to the civil laws as an implied license. The reason for not allowing to other aliens exemptions from the jurisdiction of the country in which they are found were stated as follows. When private individuals of one nation, state of the unions, or nations, under the law of nations, spread themselves through another as business or caprice may direct, mingling indiscriminately with the inhabitants of that other, or when merchant vessels enter for the purpose of trade, it would be obviously inconvenient and dangerous to society, and would subject the laws to continual infractions, and the government to the degradation if such individuals or merchants did not owe temporary and local allegiance and were not amendable to the jurisdiction of the country. Nor can the foreign sovereign have any motive for wishing such exemption. His subjects, thus passing into foreign countries, are not employed by him, nor are they engaged in national pursuits. Consequently, there are powerful motives for not exempting persons of this description from the jurisdiction of the country in which they are found, and no one motive for requiring it. The implied license, therefore, under which they enter, can never be construed to grant such exemptions. 7 Cranch 144. In short, the judgment in the case of the exchange declared as incontrovertible principles that the jurisdiction of every nation within its own territory is exclusive and absolute, and is susceptible of no limitations not imposed by the nation itself, that all exceptions to its full and absolute territorial jurisdiction must be traced up to its own consent, express or implied, that upon its consent to cede or to waive the exercise of a part of its territorial jurisdiction rest the exemptions from that jurisdiction of foreign sovereigns or their armies entering its territory with its permission, and of their foreign ministers and public ships of war, and that the implied license under which private individuals of another nation enter the territory and mingle indiscriminately with its inhabitants for purposes of business or pleasure can never be construed to grant to them an exemption from the jurisdiction of the country in which they are found. See also Carlilis versus U.S. 1872, 16 Wall 147, 155, and Radish Radich versus Hutchinson's 1877, 95 U.S. 210, and Wildas case 1887, 120 U.S. 1, 7 SUP period, CT period, 385, and Che Chan Ping versus U.S. 1889, 130 U.S. 581, 603, 604, 9 SUP period, CT period, 623. United States versus Wong Kim Ark, 169 U.S. 649, 18 S period, CT period, 456, 42 L period, ED period, 890, 1898. If you are not physically present in legislatively foreign civil jurisdiction, even if you are a constitutional alien in relation to that jurisdiction, then the above method of enfranchisement and enslavement cannot be employed. Only a corrupt government can or would waive these rules and make everyone privileged. Furthermore, under the concept of equal protection and equal treatment, if they can force anyone to be a subject to their civil laws, then you are allowed to make your own law and force anyone else, including the court, to be subject to your laws against their consent. Nationality, on the other hand, is not discretionary. Nationality is a product of the circumstances of your birth or the requirements for naturalization, which you in turn have no control over and cannot change. One can be a national of a country under Title 8 U.S.C. subsection 1101A21, have nationality, and call themselves a constitutional citizen and statutory national without being a statutory citizen because their political status is separate and distinct from their civil legal status. Yes, you can expatriate your constitutional citizenship and abandon your nationality. So giving up your nationality is therefore discretionary. When we come back, we'll talk about expatriation is the voluntary reunification or abandonment of nationality and allegiance.